Good afternoon, students. Today is Wednesday, 9 March 2022. This is our second lecture of the week. Now remember, next week is spring break, so once I get this video posted today, I won't be posting another video for 12 days. It'll be the 21st of March, and that's a Monday. Remember, I'm in the classroom on Tuesdays and Thursdays every week. Feel free to come in if you have questions about the course material. If several students show up, we can have a discussion if you'd like. On the other hand, if you want to watch the videos and stay home, that's your prerogative. You can do that. So today we're going to wrap things up with this article by Bonnie Steinbock entitled Drunk Driving. This is our third day. I have in front of me my reading list for the course. If you'd pull yours out, you can follow along. You can see that we had our first exam on the 17th of February, and we're now working our way through the 3 items that will be covered on the second exam, which is on the 31st of March. So when we finish up Steinbock today, we're ready to move on to the next item. And the next item is a famous letter written by Martin Luther King Jr. in 1963. And I've posted, or I have not yet posted, but I will over the weekend, over the following week, I should say. I will post not only King's letter in one of its earliest versions, but I will post some supplementary material. Any of it that I consider optional, I will indicate optional reading. Some of it I will not put optional reading, and that means I expect you to study it carefully and perhaps answer questions on the exam about it. So the week we return from spring break, we will devote both of those days to King's letter, and we'll also spend the following day, the first day of the following week, on King. And at that point, we will pause for our second exam on the 31st of March. Okay, today's lecture shouldn't take as long as some of the others. It'll probably go less than 1 hour. And the reason for that is that we've covered pretty much all of Steinbock except for the final section. The final section of Steinbock's essay is entitled Deterrence. Now, just to refresh your memory, Steinbock states her grand conclusion on page 279. And here's how she puts it. She says, if at least some cases of causing death by drunk driving are cases of murder, sentences should be comparable to those given others convicted of murder. And Steinbock does believe that at least some cases of drunk driving, those in which the person in question kills someone, at least some of those cases of drunk driving do constitute second-degree murder. And therefore, they should be punished, just like any other second-degree murder. Those cases that don't even involve automobiles. Now, here's an obvious objection to Steinbock's argument, and she takes it up and addresses it. The objection is that stiffer penalties on drunk drivers will not deter them. So we need to talk a little bit about deterrence. What is it? With what does it contrast? And why does Steinbock agree with the critic that there's inconclusive evidence that stiffer penalties on drunk drivers who kill deters? But we'll come to that argument in a moment. Let's talk a little bit about the concept of deterrence. There are, if you're looking at my lecture notes on page 9, I break it down for you. If our goal is to prevent crime, and we want to do that for obvious reasons, criminal behavior typically has victims. And when people are victimized, they suffer. Murder ends up depriving people of their lives. Larceny deprives people of their property, and so on. So society's goal, or one of its goals, is to prevent crime. And there are various ways to do that. If you look at my page 9, you'll see that I've listed incapacitation, rehabilitation, and deterrence. And they differ. Logically, they are different strategies for preventing crime. So let's take them one at a time. Incapacitation. When you incapacitate someone, you take that person out of commission, so to speak. You make it so that the person's desire can't be acted on. So there are, sadly, people who desire to commit crime. Now, I'm not suggesting that people get up in the morning and say, I find myself with the desire to commit a crime today. That's not how it works. People have desires to act in certain ways, and it just so happens that some of those actions violate the law. They are crimes. So we can summarize that by saying some people have a desire to commit crime, any type of crime. What can society do to act upon that desire? Well, one thing we can do is to make the desire to commit crime ineffective. For example, by confining people who exhibit a desire to commit crime. If we put you in a jail cell, you cannot act upon your desire to commit crime. There's nobody in the cell with you to rob or rape or kidnap or murder. So any kind of confinement is a form of incapacitation. And the goal is not to change or get rid of the desire to commit crime. It's to make the desire ineffective or impotent. There are a lot of ways to incapacitate people. Another way to incapacitate people is to put them in a straitjacket. When you're in a straitjacket, you can't move your arms, and that may deprive you of the opportunity to commit a crime. Okay, so that's called incapacitation. Steinbock doesn't say anything at all about that in her article. The only reason I'm bringing it up is because it's an alternative to deterrence as a way of preventing crime. Let's move on now to rehabilitation. To rehabilitate literally means to rebuild. There are people, sadly, who have a desire to commit crime. One thing society can do to get them not to act upon it is to affect their desire, to try to extinguish the desire to commit crime. And so when people are imprisoned for committing a crime, society educates them, treats them, teaches them valuable skills, so that when people are released from prison, as most people are, they no longer have a desire to commit crime. They no longer have a need to commit crime. Why? Because they now have been educated. The education allows them to get a job so that they can support themselves and their families. And sometimes people's desire to commit crime is a result of a mental illness or some kind of compulsion. That illness can be diagnosed while the person is in prison, and treatment can be provided in the form of medication or some kind of therapy. So the goal of rehabilitation is to reconfigure someone's desires so that when they're released from custody, they no longer have a desire to commit crimes. We can call that extinction of the desire. Notice that differs from incapacitation. When we incapacitate people, we don't do anything to the desire to commit crime. We leave it as it is. It's not that we don't want to get rid of the desire, but we've chosen a different strategy. We're going to leave the desire in place, but simply make it ineffective. The desire cannot be acted upon because you're in a jail cell, for example. By the way, I put in my notes lobotomy. One way to extinguish a desire to commit crimes is to perform a surgery or surgical procedure called lobotomy. Now, I'm not suggesting that that should be done or that it's very often done, but if a lobotomy were given to an habitual criminal in order to extinguish the criminal's desire to commit crimes, we would have to put that in the category of rehabilitation because we're rebuilding you. We're trying to get rid of your desire to commit crime. Let's move on now to deterrence. Deterrence is a third way to prevent crime. The goal here is to reason with the person who has the desire to commit crime. In effect, it's to give people generally a new desire. And the desire that we give them, we hope, is stronger than the desire to commit crime. So we're assuming that the person in question already has a desire to commit crime. What if we can give that person a new desire not to commit crime, and that desire is stronger than this one, the desire to commit crime? We often find ourselves with conflicting desires. On the one hand, I want to do this, but on the other hand, I don't want to do it. Right? I have both a desire to do it and a desire not to do it. What I end up doing or not doing will depend on the strength of my desires. So when we deter people, we're trying to give them a new desire that is stronger than the desire to commit crime, in the hope that they will act upon the stronger of the two desires. So where does that new desire come from, and what is it a desire to do or not to do? Well, the desire, as you can probably imagine or guess, is a desire not to commit crime. And the basis for that desire is that if you do commit a crime, we will apprehend you, try you, and if you are convicted, we will punish you. Now, very few people enjoy punishment. In fact, the whole goal of punishment is to inflict harsh treatment on people. Punishment is something a typical person does not want. We want to avoid it if we can. So, what if we threaten people with punishment if they perform certain actions, like murder or robbery or rape? If we threaten people with punishment and the threat is credible, if people really believe that we mean what we say, people might reason as follows. I have a desire to commit a particular crime, but if I do, there's a chance that I'll be apprehended by the authorities, and if so, I will in all likelihood be put on trial, and that trial could culminate in my being convicted of the crime, and that will lead to punishment. It could be severe, depending on the crime I commit. I don't want to be punished. I don't want to spend 20 years in prison. I don't want to be put to death. I don't want to have my property taken. So people reason as follows. I'd like to commit this crime, but if I do, I'm likely to be punished for it, and I strongly do not want to be punished. Therefore, I will not commit the crime. I shall not commit the crime. When people reason that way, we say that they are deterred. They have been deterred from committing crime. Notice it takes a certain amount of rationality to be deterred. Only rational beings, strictly speaking, can be deterred. A dog or a cat cannot be deterred in the strict sense because they can't reason. Right? Presumably a dog cannot reason. If I would like to chase after that animal, another dog, let's say, but if I do, my master will whip me or kick me or somehow punish me. But I don't want to be punished, therefore I'd better not chase after that dog. Right? That requires probably more reasoning than a dog is capable of. And I'm a dog lover. I'm not putting dogs down. I'm a realist. Dogs are simply not capable of the forms of reasoning that humans are, the normal human anyway. So while you can incapacitate a dangerous dog, maybe even rehabilitate a dangerous dog through conditioning or training, you can't deter a dog, and probably any other animal as well. But humans, the typical human, can be deterred. And that's one of the aims of criminal punishment, to deter others from committing crimes. And by others, what I mean is, if we punish person A and publicize that punishment, we deter other people from committing the very crime that A is being punished for. That's called general deterrence. We're trying to deter people generally by punishing certain people, those who have committed crimes. Now, the argument that we're about to discuss is based upon deterrence in this strict sense that we've been talking about. So here is my reconstruction of the argument. This is not Steinbock arguing this. This is a critic of Steinbock. And when we're done examining the argument, we will ask, what would Steinbock say about it? How would she find fault with it? So here we go. It's short. It's only one argument. Unlike some of the other arguments we've discussed, it's not a chain argument. So you'll notice the word therefore appears only one time. So here we go. First premise, and this is a moral claim. The critic says stiffer penalties for drunk driving are justified only if they deter. Now remember, Steinbock is advocating stiffer penalties for certain drunk drivers, those who kill, those who display a depraved heart, those who fall into the category of second-degree murderers. Okay, that's the argument we've looked at already. Typically, traditionally, those kinds of murder have been punished as involuntary manslaughter. Steinbock is advocating that they be punished more severely as second-degree murder. So she is advocating stiffer punishments, more severe punishments. So the critic says, wait a minute, Steinbock, stiffer penalties for drunk driving are justified only if they deter. The critic is saying that it's a necessary condition for imposing stiffer punishments that they deter people from engaging in drunk driving. And that's a moral claim. The moral claim has to do with the word justified, morally justified. Okay, we'll come back and ask what Steinbock would say about that in a moment, but let's get through the argument. The second premise of the critic's argument is a factual claim. It says stiffer penalties for drunk driving don't deter. And in order for that premise to be justified, the critic would have to cite reputable studies that have shown that stiffer penalties do not, in fact, deter drunk driving. So that's a factual claim. When you put these premises together, you can extract or deduce or derive the following conclusion. Stiffer penalties for drunk driving are unjustified. And once again, that's a moral claim because of the word unjustified. So the critic's argument is pretty simple, really. If you just, I've formalized it on page 9 of my notes. But really, the critic is saying to Steinbock, we can't or we shouldn't increase the penalties for drunk driving unless we have good reason to think that that would deter drunk driving. And we don't have good reason to think that it does. Therefore, we shouldn't impose stiffer penalties on drunk drivers. Now, Steinbock is not going to be happy with that conclusion, right? The conclusion says that stiffer penalties are unjustified. And that goes directly against Steinbock's claim in this article, her argument that stiffer penalties are justified. So Steinbock has to find fault with this argument somehow. She has to claim either that the conclusion does not follow from the two premises. In other words, she has to claim that it's an invalid argument, or she has to find fault with the first premise, or she has to find fault with the second premise. My judgment is that she finds fault with both premises. Remember, in order for her to avoid this conclusion, all she has to do is find fault with one of the two premises. In fact, I think she would find fault with both of them. And you might wonder, well, why bother finding fault with both when one suffices? And the answer is, what if she put all of her eggs in one basket, so to speak? What if she said that there's a problem with the first premise? Maybe she's wrong about that. Maybe she thinks that the first premise is false, but in fact it's true. She would like to have a fallback position. If her criticism of the first premise fails, she can fall back on her criticism of the second premise. And that's also always a useful thing to do. Find fault with as many premises of the argument as you can. And I think she has a good case that both of these premises are at fault or are problematic. Let's take a look. As I say in my notes on page 9 near the bottom of the page, Steinbock denies premise 2. Now we'll come back to 1 in a moment. Steinbock denies premise 2 on the ground that the evidence about deterrence is inconclusive. Premise number 2 asserts very boldly that stiffer penalties for drunk driving don't deter. That's a bold factual claim. And Steinbock says, hold up. Do you have any solid evidence to support that bold factual claim? And her judgment is, having looked at the evidence, is that the evidence is inconclusive. We simply do not know, at least we didn't at the time this article was written and published, we don't know whether stiffer penalties on drunk driving actually deter drunk drivers. And in the absence of knowledge on that matter, we can't affirm the second premise of the argument. The second premise makes a bold affirmative claim. It says stiffer penalties don't deter. And Steinbock says, not proven. Right? We don't know that. And that's a problem with this argument. The critic is putting too much weight on the factual judgment of deterrence, and the evidence doesn't support it. And that seems to be one of the problems Steinbock has with this argument. It rests upon a factual claim that has not been established by the experts. Remember, Steinbock is a professional, credentialed philosopher. She is not a social scientist. However, she, like any intelligent person, can do research and read the studies that have been conducted by reputable social scientists and form her own conclusion. And Steinbock has done that. She says that having looked at some of the studies on deterrence, she's come to the conclusion that they're inconclusive. She's concluded that they're inconclusive. So we need more and better studies. Perhaps one day, and maybe by now, since it's 2022 now, a lot of time has passed since this article appeared, maybe there's now a consensus among social scientists that stiffer penalties on drunk drivers do deter drunk driving. That's a possibility. If that were the case, then Steinbock would give up her attack on the second premise. She would concede that it's true. But there's another possibility. Actually, there are two other possibilities. It's also now possible that further studies of this issue have shown that stiffer penalties on drunk driving do not deter. That may now be the consensus of the relevant experts. And if so, then this argument is unsound, right? It would have a false second premise. The third possibility is that things are today the way Steinbock thought they were back in 1985. Maybe the studies are still inconclusive. So there are three possibilities. I'm going to use my hands. On the one hand, it may now be in 2022 that there's conclusive evidence that stiffer penalties on drunk driving deter. It's also possible over here that studies now show that there's conclusive evidence that stiffer penalties on drunk driving do not deter. The third possibility is in the middle, right here, and that the studies now show the studies are still inconclusive. So there are three possibilities. In two of them, the second premise should be rejected. In only one of them should the second premise be accepted. So you might say that Steinbock has two chances out of three of being able to reject the second premise. 2 out of 3. Either the studies currently show that it's inconclusive, or the studies conclusively show that there's no deterrent effect. I'm sorry, that there is a deterrent effect. Only in the case where the studies are conclusive that there is no deterrent effect will the second premise be acceptable, because it says stiffer penalties don't deter. Okay, so whether the second premise is justifiable, true, acceptable, comes down to the facts. Right? It's hostage to the facts. And the only way to find out is to do the research and find out. Let's turn to the first premise of this argument, because I said that Steinbock finds fault with it as well. If you look at my notes near the bottom of page 9, I say the following. She, referring to Steinbock, denies premise 1 on the ground that there are other justifications besides deterrence, namely retribution. So premise number 1, notice it says it's a necessary condition for stiffer penalties to be justified that they deter. Steinbock says, wait a minute, that's false. There are other justifications for stiffer penalties besides deterrence. Deterrence may be one justification, but it's not the only one. And so she points out that another common justification for criminal penalties or stiffer penalties is retribution. Now, retribution means paying people back for their crimes, whether any good will come of it or not. If you've committed a crime, you deserve to be punished. That's the retributivist view. And we've already talked about this in this course at some length, so I'm not going to repeat everything I've said. What I'll say now is that Steinbock thinks that drunk drivers who kill, especially those who display a depraved heart, those who have had many incidents of drunk driving, always made it home safely, but finally ended up killing someone, those people display or manifest a depraved heart. And if on a particular occasion they kill while drunk driving, they fall into the category of second-degree murderers. And they deserve to be punished as second-degree murderers. That's retribution. That's not deterrence. If punishing such people deters them or deters others, that's good. That's a good consequence of the punishment. But that is not a necessary feature. The punishment would be justified even if it didn't have any deterrent effect at all. What would justify it? Giving the drunk drivers who kill what they deserve, paying them back for their misdeeds. So Steinbock falls back in her criticism of the first premise. She falls back on the retributive justification for punishment. Now, is Steinbock a retributivist in general about punishment? I don't know. She doesn't say anything about that. All she says is that one commonly expressed purpose of our criminal law is retribution, namely giving people what they deserve, paying them back for their misdeeds. And as long as that is considered a legitimate function of punishment, a legitimate justification of punishment, then we should apply it across the board. We should apply it for all crimes, not just certain crimes. And if she's right that some drunk drivers are second-degree murderers, then they should be punished as second-degree murderers. They deserve it. That's giving them what they are due. That's justice, retributive justice. Okay, so let's turn the page 10. I've now covered both premises of the argument. Look under my subsection entitled Law and Morality, because that states, in other words, what I just told you. Steinbock's argument is conditional in nature. It's not unconditional. It's conditioned on something being the case. Here's how I put it. Given, and this is, I think, what Steinbock would agree with, Given that we have second-degree murder, a crime called second-degree murder, we should be fair and consistent in applying it. This requires that some drunk drivers, those with depraved hearts who end up killing, be charged with second-degree murder. Now, I then add, it's an open question whether Steinbock thinks we ought to have a crime called second-degree murder. She doesn't, at any point in this essay, try to justify the crime of there being a crime called second-degree murder. She simply accepts that there is such a law, there is such a crime on the books, and she says, let's punish people fairly. Let's punish people consistently. If we're going to have a crime, second-degree murder, let's apply it uniformly across the board to all those who fall within the terms of that crime. All right, we're almost done for the day. I have a section called Criticisms of Steinbock's Argument. And some of these may have occurred to you as we went along. And I've broken them down into two parts. Someone might argue that Steinbock's argument proves too much and is therefore in some way a bad argument. And someone might also claim, ironically or oddly enough, that it proves too little. It doesn't go far enough. So different critics say it goes too far, it doesn't go far enough. Someone could say both. Someone could say, the same person could say, we need to reject Steinbock's argument for two different reasons. It goes too far, it goes not far enough. It proves too much, it proves too little. So let's take these one at a time. Under the heading of it proves too much, the objector or critic of Steinbock might say, a person shows extreme indifference to the value of human life by driving while intoxicated, even if nobody is killed. Thus, both those who kill and those who don't kill, those would be the lucky ones, should be punished as second-degree murderers. Morally speaking, all drunk drivers are murderers. Now let me explain what I'm talking about here. The mental state of the guilty mind, if you will, or what is called in Latin the mens rea. The mens rea of a drunk driver is driving in aware of getting into a car in awareness that you've been drinking and that you thereby pose a danger to others while you're driving that car. Now, the crime, you might say, is committed whether you strike and kill someone or not. Morally speaking, maybe not legally speaking, but morally speaking, you are a murderer the moment you get in a car and start driving it while drunk. And if you make it home safely without striking and killing someone, it's only a matter of luck. You've experienced good luck. You were lucky that evening. It's through no merit of yours that you didn't strike someone. It was just good luck. Morally speaking, you're just as much to blame as someone who did strike a pedestrian and kill him or her. To see this, imagine two situations that are alike in all respects except one. Here they are. This is drunk driver number one. This is drunk driver number two. Both of them have driven drunk in the past and never had any incident. They've never harmed anybody. On a particular occasion, they each drive to a bar knowing that in all likelihood, based upon past experience, they will get drunk, that they will then get back into the vehicle and drive home. Everything's the same in these two cases. In one case, let's say this one, on the way home, you strike and kill a pedestrian. In this case, you don't. You make it home, go to bed, sleep off the drunkenness. Okay? Morally speaking, these people are the same. Right? One of them happened to kill someone. The other one happened not to. But that's through no merit of the two individuals. What they did and what they knew is the same. So, morally speaking, at least, they're both murderers. It's just that one of them was lucky and didn't end up killing someone. The other one was not lucky. Now, legally speaking, obviously, since no death occurred in one of those two cases, there's no homicide. And if there's no homicide, there can't be a murder. And if there's no murder, there can't be a second-degree murder. And if there's no second-degree murder, there can't be any crime or trial or punishment. So my point is that a critic might say that Steinbock's argument proves too much. It proves that people who drive while drunk should be punished whether they kill someone or not. Now, what we would call it, I don't know. It wouldn't, strictly speaking, be second-degree murder because, as I just said, no one's been killed. But maybe we could call it attempted second-degree murder. And I can tell you that attempted crimes in the law are punished just as severely as the completed crime. So a critic might think that this is a problem with Steinbock's argument. It proves too much. It goes too far. Because intuitively, many people would say that we shouldn't punish drunk drivers who don't kill anyone. At least we shouldn't punish them as second-degree murderers. Okay, let's turn to the second criticism, the one that says Steinbock's argument proves too little. We've already discussed this briefly. Only a small percentage of drunk drivers who kill have depraved hearts. Only a small percentage. In other words, Steinbock's argument covers only a small fraction of drunk drivers, perhaps those who are repeat offenders, those who have driven while drunk repeatedly and finally end up killing someone. So the argument is that this is much ado about nothing. Only a few people are covered by Steinbock's argument. Those are the repeat offenders. Now, Steinbock would reply to this, I think, as follows. She would say, well, it doesn't matter how many people fall into this category. It's better that some drunk drivers get what they deserve than that no drunk drivers get what they deserve. In other words, Steinbock would meet this criticism head on and say, it's not the numbers that matter. My argument applies to a certain class of people, however many people fall into that class. Maybe it's only one. Maybe logically it could be none. But she would say almost certainly there are members of the class, and they should be punished as second-degree murderers. Maybe there are far more second-degree murderers than we think. Right? Maybe the class contains a lot of members. But I think Steinbock could reply by saying that it doesn't make her argument moot or irrelevant. It just means that she's talking about a numerically small group of people. Okay, there were other issues that I might have discussed with you in a classroom setting, just to kind of throw it open if we had extra time, which we do today. But I'll just raise these discussion questions and you can think about them on your own. Obviously, I won't be asking exam questions about them. But should Steinbock's argument be extended to cover not just people who are driving while drunk or otherwise intoxicated with some mind-altering substance, but what about people who are habitually inattentive to their driving and whose driving is therefore extremely dangerous? Dangerous to the point where it displays or manifests extreme indifference to the value of human life. And I'm talking about, as you can see from my notes on page 11, I'm talking about people who fiddle with their cell phones while driving. And it shocks me to say this, but some automobiles now have the equivalent of a cell phone built into them in a little display on the console of the vehicle. Now, if that's not an invitation to death and destruction, I don't know what is. I don't know why the law would allow that, frankly. It would seem to be a law that prohibited automobile manufacturers from putting electronic devices in their consoles that are visible to the driver at all times. That would be illegal. It would seem to me that that's a law that could be justified on the grounds that it's for the common good. It's for the good of all of us. Every pedestrian, every bicyclist, every other person in a vehicle on the roadways. Now, people get absorbed by their cell phones, whether they're handheld or built into the vehicle. I've seen it myself many times. I understand that it's tempting. You're sitting at a red light and you know it's going to be a few seconds, maybe as much as half a minute before you get to move. So you reach down, you grab your phone, and you start checking your email or text messages or something like that, or God forbid, watching TikTok. Now, it may be that if you're doing that, well, stop, that's not dangerous. But what if the light turns green and you notice it, you look up and notice it, you put your foot on the gas and start moving and almost instantly go back to your phone because presumably you were looking at something when the light turned green. You are now a danger to everyone in your vicinity. And I'm not even talking right now about people who are driving on a freeway at 60 or more miles per hour, looking at their phones. Now, talking on a phone may not be as dangerous, although it's still more dangerous than not talking on a phone, because at least when you're talking on a phone, holding it to your ear, at least your head is up and you're looking forward. And while you're driving with one hand instead of two, at least you have some control of the vehicle and you can see in front of you. But what if you are looking down at your phone instead of talking on it with your head up, you're looking down. You're not even looking at the road any longer. The vehicle in front of you could slow suddenly and you might cause a rear end collision that could cause the car in front of you to explode and burn the inhabitants to death. And of course, a lot of lesser injuries could occur, whiplash, broken bones, things like that. So texting drivers are dangerous, maybe as dangerous as drunk drivers. And if that's true, then Steinbock's argument would apply to them as well. Were there cell phones in 1985? I don't think there were. There were no phones. Maybe there were those big contraptions that were cordless phones. I don't know that they would work in an automobile. Maybe not. You could, I suppose, be driving along talking on one of those. But you're probably not going to be looking down, checking email. I mean, those phones didn't have internet connections or email, things like that. So I wonder sometimes, what would Steinbock say about texting drivers who kill? She might well write another article applying the argument from this article to the new dangerous situation. Okay, but even if she doesn't do that, we can imagine how that argument would go. And that's all I'm inviting you to do. Okay, my last comment or discussion matter is this. Did you know that in Texas, if you are convicted of drunk driving 3 times, the 3rd time it occurs, you are considered a felon? Right? A single drunk driving conviction is a misdemeanor. That doesn't mean it's not serious. It's still a serious offense. But if you're convicted 3 times, the law ramps it up from a misdemeanor to a felony. You are now considered a felon. And the punishment for felony is much greater than it is for any misdemeanor. Now, let's think about this. Remember earlier when we talked about second-degree murder? We said that there are 3 types of second-degree murder. You can get that taxonomy out right now if you want to look at it. The 3 were felony murder, intent to do serious bodily injury murder, and depraved heart murder. Steinbock's article is about depraved heart murder, which is a kind of second-degree murder. In Texas, if you are convicted of drunk driving a third time, you are a felon. If you happen to kill someone on your third drunk driving incident, you have committed felony murder, which is a form of second-degree murder and punished very severely. So when you connect up the fact that Texas makes a third drunk driving conviction a felony with the traditional common law rule known as felony murder, you end up as a second-degree murderer, a felony murder. And there have been cases already in Texas involving this. One of them is the case called Strickland. And I have my copy in my notebook. Let me see where I can give you the full title so that you can look it up. I know it's in here somewhere. Hold on. I put all my cases together. It's Jake Strickland versus State. Strickland versus State. It involves a young man named Jake Aaron Strickland. He was convicted a third time of drunk driving. He was sentenced to 35 years in prison for felony murder. And he appealed his conviction and he lost. The Court of Appeals of Texas affirmed his conviction, and I believe that the Texas Court of Criminal Appeals affirmed that lower court ruling. So Jake Strickland, a repeat offender as far as drunk driving goes, is spending 35 years in prison because he has 3 drunk driving convictions, and that makes him a felony. And he killed someone on the third incident. Let me see whether I can get the facts very quickly for you of who was killed. He was driving on the wrong side of the road when his vehicle struck the car driven by Brent Jones, who was a passenger. Jones was killed. So Strickland, while driving drunk, struck and killed at least one person, Jones. He was convicted of drunk driving. Under Texas law, that was his third drunk driving conviction. That made him a felon. And since he killed someone, Jones, he was then a felon. He was convicted of felony murder. And the sentence he received for that was 35 years in prison. So there are intellectual lessons to be learned from this, but also practical lessons. If you care about your liberty, you will think long and hard before you get into a motor vehicle having consumed alcohol. You owe it morally to other people, and the law will punish you severely. Maybe not as severely as Steinbock thinks you should be punished, but still, even a single conviction for drunk driving will result in a stiff fine and perhaps some jail time. Okay, I'm starting to sound like a preacher, but it is a shame, I think you'll agree with me, that so many lives are lost in this country as a result of drunk driving. These are absolutely unnecessary, pointless deaths. People's lives are snuffed out, including that 4-year-old boy named Gunderson, who was standing waiting for the ice cream truck. One moment, and the next moment, he has no longer any life. Everything that makes life worth living was denied to him in that moment. Tragic and very sad. Okay, that's enough for now. We've covered Steinbock's essay. You have my lecture notes. You now have 3 full lectures in which I try to make all these concepts, distinctions, and arguments clear to you. There will be exam questions, obviously, on this article. About 1/3 of the exam will cover this article. I'm currently in the process of drafting the exam, which you will take on the 31st of March. Have a great spring break. On the 21st of March, which is 12 days from now, I will record and post the next lecture. and it will be on Martin Luther King's famous essay. And I will be posting items on King and his letter, not his essay, but his letter, during the break. So keep checking Canvas along the way, and make sure you print what you find there. And unless it says optional reading, you should read it carefully and be prepared to answer questions about it on the exam. Again, have a great day, have a great weekend, have a great spring break, and I'll see you in a few days on the screen.